Imagine a world where the very first breath a child takes on American soil does not guarantee them a future in the United States. A maternity ward where a newborn infant, mere seconds old, is already classified by the federal government as an undocumented alien simply because of the paperwork their parents lack. For 156 years, the 14th Amendment has stood as an unshakable pillar of American law, guaranteeing that the location of one's birth equals citizenship, a bright-line rule that has defined our national identity and served as a beacon of hope for generations. But as we approach the pivotal year of 2026, the ground is shifting beneath our feet, with a draft executive order circulating in the highest levels of government that seeks to dismantle this constitutional bedrock, and the consequences will ripple through every community, every school district, and every hospital in this nation. This is not a drill, and it is not just political rhetoric meant to stir up a base. It is a concrete, detailed policy proposal that could redefine the very concept of we the people and fundamentally alter the social contract of the United States. Welcome back to U.S. Immigration Insight, your premier destination for unvarnished, deep-dive analysis of the U.S. immigration system, where my name is your name. And today, we are tackling the single most explosive, controversial, and consequential topic in immigration law: the potential termination of birthright citizenship via executive action. This proposal threatens to create a new permanent underclass of stateless children, burden our schools and hospitals with impossible enforcement duties they are neither trained nor funded to handle, and ignite a constitutional crisis that will inevitably end up in the Supreme Court, determining the fate of millions. Whether you are a green card holder, a visa holder, or a U.S. citizen, this policy affects the fabric of the society you live in. So stick with me until the very end of this video, because we are going to dissect the legal arguments, expose the practical nightmares of implementation, and provide you with a survival guide on how to protect your family's status in this volatile era. To fully grasp the magnitude of what is being proposed, we must first look backward to the principle of jus soli, Latin for right of the soil, which is encoded in the first sentence of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This amendment was the nation's specific legislative answer to the stain of slavery and the infamous Dred Scott decision, ensuring that formerly enslaved people and their descendants could never be denied citizenship again by state governments. For generations, this has been interpreted as a system that promotes assimilation, ensuring that the children of immigrants, regardless of their parents' status, start life with the same rights, the same potential, and the same legal standing as the children of the president. This principle has been the cornerstone of American exceptionalism, fostering a cohesive society where every child born here has an equal stake in the nation's future, preventing the balkanization of our population into castes based on lineage, and reinforcing the idea that American identity is rooted in shared values and geography, not bloodlines or aristocracy. It is a unique feature that separates the Americas from much of Europe and Asia, where citizenship is often jealously guarded by blood. However, a growing, sophisticated movement of legal theorists and policymakers argues that this interpretation is historically flawed and legally unsound. They contend that the phrase, subject to the jurisdiction thereof, was never meant to be a throwaway line, but rather a specific disqualifier meant to apply to people who are in the country without the government's consent. They argue that a foreigner who crosses the border illegally owes allegiance to a foreign power, not the United States, and therefore their children, born on U.S. soil, do not inherit the requisite political allegiance to become automatic citizens. This consensualist theory of citizenship posits that citizenship requires mutual consent between the government and the governed, and since the government did not consent to the parent's presence, it does not consent to the child's citizenship. This intellectual framework is the foundation for the executive order expected in 2026. They argue that the intent of the 14th Amendment was solely to address the citizenship of freed slaves and not to provide a blanket right to anyone who happens to be born within U.S. borders, effectively calling for a return to a pre-1898 interpretation of the law. This reinterpretation hinges on a narrow reading of jurisdiction, claiming it implies not just being subject to U.S. laws, which everyone in the country, including tourists, is, but also a consensual, complete political allegiance that they argue unauthorized immigrants and temporary visitors cannot possess. So, what exactly does this new policy look like in practice? Based on leaked memos and policy papers analyzed by experts, the executive order would direct federal agencies, specifically the State Department and the Social Security Administration, to stop issuing passports and Social Security numbers to children born in the U.S. unless at least one parent is a U.S. citizen or a lawful permanent resident, green card holder. This would fundamentally shift the burden of proof from the government to the parents. Currently, a birth certificate is the golden ticket. Under the new regime, a birth certificate would merely be proof of place of birth, not proof of citizenship. Parents would have to prove their own legal status, showing a green card, a certificate of naturalization, or a U.S. birth certificate, in order to confer citizenship upon their newborn. This would fundamentally alter the administrative state, turning every application for a child's documents into an intricate adjudication of the parent's immigration history, creating a bureaucratic bottleneck of epic proportions. This would effectively end birthright citizenship for three major groups, creating immediate and distinct crises for each. First, the estimated 11 million people living in the U.S. without status would no longer be able to have U.S. citizen children. Their babies would be born undocumented, inheriting the legal precarity of their parents. This would create a generational cycle of unauthorized status, where children grow up in the shadows, attend U.S. schools, speak English as their first language, yet possess no legal right to work, vote, or remain in the country they call home. It would essentially create a stateless caste within American borders, similar to the situation of the Rohingya or other marginalized groups globally. Second, and this is the shocker for many who believe they are doing it the right way, parents lawfully in the U.S. on non-immigrant visas, such as H-1B skilled workers, F-1 students, L-1 intracompany transferees, and B-2 tourists, would also be excluded. This means a child born to a tech worker in Silicon Valley who has lived here for 10 years, or a PhD student in Boston conducting cancer research, would be considered a foreign national, dependent on their parents' visa to stay. If the parents lose their job or finish their studies, the child must leave with them, effectively treating U.S.-born children as guests in their own birthplace. Third, the policy is explicitly designed to target birth tourists, foreign nationals who travel to the U.S. solely to give birth to secure a passport for their child, a practice that critics argue commodifies American citizenship and exploits the generosity of the Constitution. Let's humanize this abstract policy by considering the hypothetical yet entirely plausible case of Elena, a graduate student from Brazil on an F-1 visa, who has lived in the U.S. for 6 years, pays taxes, follows every law, and is working toward a degree that will benefit the U.S. economy. Under the new proposal, if she gives birth in a Chicago hospital in 2026, her daughter would not be an American citizen. Instead, the child would take on the visa status of the mother. If Elena's visa expires, or if she loses her student status due to a clerical error or academic struggles, her U.S.-born daughter would have to leave with her because there is no anchor, no safety net keeping the child here. Elena's daughter would have no claim to remain in the country of her birth, potentially facing deportation to a country she has never seen and whose language she may not speak. Or consider Mateo, a construction worker who has lived in Texas for 15 years without papers, has built the homes Americans live in, and has no criminal record. If he has a son in 2026, that boy will grow up in Texas, pledge allegiance to the Texas flag in school, speak English with a Texas drawl, play football on Friday nights, but legally be a stranger in his own land. He will be ineligible for financial aid for college, unable to get a driver's license in many states, barred from legal employment, and constantly at risk of deportation to a country he has never seen. This creates a hereditary illegality, a caste system where unauthorized status is passed down from parent to child like a genetic trait, creating a permanent underclass of millions of people who live, work, and die in America without ever being recognized as part of it. These children would effectively be stateless within their own communities, marginalized and excluded from the civic life of the only nation they know, fostering resentment and social instability. The moment this order is signed, the lawsuits will fly, centering on one fundamental constitutional question. Can a president change the meaning of the Constitution with a stroke of a pen, or does it require a constitutional amendment? Most legal scholars say no, pointing to the seminal 1898 Supreme Court case, United States versus Wong Kim Ark, which affirmed that a child born to Chinese parents, who were legally barred from citizenship at the time due to the Chinese Exclusion Act, was indeed a U.S. citizen. This precedent is the fortress protecting birthright citizenship. This case established that the 14th Amendment applies to all children born in the U.S. to parents who are not foreign diplomats or occupying enemy forces. It is a robust precedent that has stood for over a century, cited in thousands of subsequent cases. However, proponents of the new policy believe the current Supreme Court, with its conservative supermajority, might be willing to revisit Wong Kim Ark. They argue that the court in 1898 never explicitly ruled on the specific question of children born to undocumented parents or tourists, as immigration controls in the 19th century were vastly different. They believe there is a narrow interpretive lane to redefine jurisdiction to exclude these groups without overturning the amendment itself. They contend that the circumstances of the 19th century are different from today's massive global migration flows, and that the court should adapt its interpretation to modern sovereignty concerns. This is a high-stakes gamble because if the Supreme Court upholds the executive order, it would fundamentally alter the American social contract, effectively amending the Constitution without the rigorous process required by Article 5. But if they strike it down, we could see a push for a constitutional amendment, a much harder hurdle to clear, but one that would permanently settle the issue in the political arena. Beyond the courtroom, the practical implementation of this policy would be a logistical disaster, creating immediate chaos in delivery rooms across the country. Nurses, doctors, and hospital administrators are not immigration officers. They are trained to save lives, not verify visas. Yet, under this new regime, to issue a birth certificate that confers citizenship, someone would have to verify the parent's status. Would women in labor be required to bring their passports and visa documents to the ER? Would hospitals deny birth certificates to those who forget their green card in the rush to the hospital? The administrative burden on healthcare providers would be immense, distracting from patient care and potentially deterring vulnerable populations from seeking medical assistance during childbirth for fear of deportation, leading to a public health crisis involving increased infant and maternal mortality. The state-level conflict would be intense because birth certificates are state documents, not federal ones. Liberal states like California, New York, and Illinois have already signaled they would refuse to comply with federal orders to restrict birthright citizenship documentation. This sets up a massive federalism showdown where a child might be recognized as a citizen by their state, receiving a state birth certificate, but denied a passport by the federal State Department. We could end up with a patchwork system where your rights depend entirely on which side of a state line you were born on, leading to dual systems of documentation and immense confusion for families trying to navigate bureaucracies that are at war with each other. A child could be a citizen in Los Angeles, but an alien in Dallas, creating a nightmare for interstate travel and commerce. There is a darker, often overlooked international dimension to this because not all countries grant citizenship based on blood, jus sanguinis. Some countries only grant citizenship if the child is born on their soil. If the U.S. stops granting citizenship by soil and the parent's home country refuses to grant it by blood or requires difficult registration processes the parents cannot complete due to being abroad, We risk creating true statelessness. These are children who belong to no nation, legal ghosts with no passport, no consular protection, and no right to travel anywhere. The U.S. has historically championed the reduction of statelessness globally. This policy would make the United States a primary generator of it, violating international human rights norms and leaving innocent children without the basic right to have rights. Imagine a child who cannot leave the U.S. because they have no passport, but cannot stay because they have no visa, a prisoner of bureaucracy. So, what can you do in the face of this uncertainty? At U.S. Immigration Insight, we believe in preparation, not panic. First, secure documentation now. If you have children already born in the U.S., do not take their status for granted. Even if you have a birth certificate, apply for their U.S. passports immediately. A passport is the gold standard of citizenship proof and represents a federal adjudication of citizenship. Even if the law changes later, it is extremely difficult for the government to revoke a passport that has already been issued, as it acts as proof that the citizenship was already vested. Second, organize your records. If you are pregnant or planning to start a family, ensure every document regarding your own status is pristine. If you are a green card holder, ensure your card is unexpired and your renewals are filed. If you are a visa holder, keep your I-94 arrival records, approval notices, I-797, and employment letters accessible. You may need to prove your status at the hospital or the Vital Records office to ensure your child's paperwork is processed correctly. Being able to demonstrate lawful status quickly could be the difference between your child receiving a birth certificate marked citizen or one that leaves their status ambiguous. Third, consult a lawyer. If you are undocumented or in a gray zone status, like pending asylum, DACA, or TPS, speak to a qualified immigration attorney to understand how the laws of your home country work regarding citizenship transmission. You need to ensure that if the U.S. denies citizenship, your child can at least acquire citizenship from your home country so they are not left stateless. Knowing the specific registration requirements of your country of origin is crucial. Fourth, stay vigilant. Misinformation will run rampant with rumors spreading on WhatsApp, WeChat, and social media, creating unnecessary panic. Do not rely on hearsay from friends or unverified online posts. Rely on verified legal sources and subscribe to channels like U.S. Immigration Insight that prioritize accuracy over clickbait. In times of policy upheaval, scammers often prey on fear, selling fake citizenship insurance or bogus legal services. Verified information is your best defense against exploitation. This debate forces us to ask a profound question. What is America? Is it a club with a velvet rope, accessible only to those with the right pedigree and paperwork? Or is it an idea, a place where geography and destiny intersect to create new citizens, regardless of their lineage, binding them to the Constitution rather than to their ancestors? Ending birthright citizenship would bring the U.S. in line with most of Europe and Asia, where blood determines nationality, but America has always claimed to be different. An exception, a nation of immigrants. Abandoning jus soli is abandoning that exception. It challenges the inclusive vision of the 14th Amendment and risks moving us toward an ethno-nationalist conception of citizenship that is alien to our constitutional history and values. As we move toward 2026, this issue will become a defining political wedge used to rally bases and demonize vulnerable populations. We will see heated rhetoric on cable news and social media, but behind the shouting matches are real babies, real families, and real futures hanging in the balance. The impact will be felt in nurseries, schools, and homes across the country. It is a policy that touches the most intimate aspect of family life, the birth of a child, and turns it into a political battleground. The uncertainty alone is damaging, causing stress for expectant mothers that can lead to adverse health outcomes. At U.S. Immigration Insight, we will stand watch. We will analyze every draft, track every lawsuit, and translate every regulation so you are never caught off guard. We understand that behind every policy proposal are real people trying to build lives and families. We are committed to providing you with the most up-to-date, legally sound analysis so you can make the best decisions for your loved ones. If this video helped you understand the magnitude of what is coming, please share it. Send it to your family group chats, post it on your timeline, and discuss it with your community. The more people who understand the stakes, the better we can navigate the storm together. Knowledge is the only antidote to fear. Thank you for trusting us with your time. Stay safe, stay legal, and never stop fighting for your American dream.